Further hearing in the appeals of Lord Debenture Trust Corporation plc against Ukraine.
Yes, Mr. Thank
My Lords, amongst other accusations in the opening paragraph of the trustee's first written case is the statement that Ukraine is a recalcitrant debtor. My client has no problem in accepting the label of recalcitrant. Russia's actions in the Crimea and in the eastern provinces of Ukraine have wiped out many times over the sums in issue in this case. Given what Russia has done to my client, no borrower would wish to repay a penny if it has available defences. We of course accept that the background to this claim, which the Court of Appeal had to grapple with, is unusual and on any view extraordinary. In the words of the previous Prime Minister of the United Kingdom, Russia's illegal annexation of the Crimea was the first time since the Second World War that one sovereign state has forcibly taken territory from another in Europe. The damage to Ukraine, its people and its economy is summarised in the annex to Mr. Justice Blair's judgment at paragraph 77, which I won't turn up now. So Ukraine will accept the label of recalcitrant. The question confronting the English courts is whether there is an enforceable debt. Now, as Mr. Justice Blair noted, this is not, as the trustee had suggested, an ordinary debt claim, judgment paragraph 272. There is no challenge to Mr. Justice Blair's conclusion that Ukraine's duress defence is a strong one and has not been answered. However, he concluded that the Foreign Act of State principle meant that it was unsuitable for the English court to adjudicate upon it. As the court has seen, the Court of Appeal took a different view. Now, listening to Mr. Howard yesterday, one might be forgiven for thinking that Lord Sales had lost sight of the principles of Foreign Act of State, but the Court of Appeal had well in mind the references to making war and peace and annexation in Belhaj, which Mr. Howard took you to yesterday. They quote at paragraph 123 of Lord Neuberger's judgment, at paragraph 170 of the Court of Appeal judgment below. The Court of Appeal concluded that although the Foreign Act of State principle was prima facie engaged by matters of high policy on the international plane, the public policy exception arguably applied, it's paragraph 173 of their judgment, such that summary judgment was inappropriate. And one shouldn't lose sight of the fact that this is, at the end of the day, a summary judgment application. The Court of Appeal, in fact, went into detail in the following paragraphs with why the case was on its unusual facts, an appropriate and suitable one for judicial determination. So, suitability is an issue that requires careful evaluation of the principles of Foreign Act of State, including the public policy exception. But in our submission, the argument that Ukraine's duress defence is irrelevant to the contractual claim brought on behalf of the Russian Federation, which necessarily asserts the validity of the contract, is, in our submission, a startling one and is wrong. That is why the Court of Appeal correctly concluded that if Ukraine's duress defence was in fact unsuitable for determination by the English court, then the only fair outcome would be a stay, as in the Buttes case. Russia, in fact, did to Ukraine exactly what it had threatened to do in the run-up to the issue of the notes, to use violence against the people of Ukraine and to take measures which were not taken for bona fide reasons on our pleading, with devastating effects on Ukraine. The Court of Appeal correctly concluded that the threats were capable of satisfying the test of illegitimacy set by the English law of duress, see paragraph 159 of their judgment. Now, yesterday Mr. Howard would appear to have accepted that if Russia had threatened to kill the Ukrainian finance minister unless she signed the contract, then that could amount to a deflection of the will, vitiating true consent under the English law of duress. But apparently, if the threat were instead to annihilate the country, that is apparently said to be legally irrelevant. Now, one can see...
A moment ago you said that you referred to the judgment of the High Court and said there was no challenge to Mr. Justice Blair's view on the duress claim in
strength
principle.
of the duress claim.
Which was the paragraph you referred to?
272, my lord.
272. Thank you. Sorry.
$272 was where he said it was not an ordinary debt claim, and if I can just give you the references to where he deals with the duress claim, it's principally paragraph 308.
308.
308.
Can you help me on another point? Again, it's not quite strictly relevant. Is it clear that at the time the Ukraine minister entered into the debt, they in effect were saying we're doing it because a gun is being held to our head?
Yes. In fact, I'll show you the references. In fact, the prospectus itself of the bond transaction makes clear that there were punitive trade sanctions imposed by Russia, and that was one of the reasons why Ukraine was entering into this transaction.
Again, when it's convenient,
I will
drive the reference.
Can I come back, my lord, in a moment to give you the
thank you.
references? But I think the key references you will find a paragraph 308 dealing with the threats of aggression, and I'll come back to where he deals with the strength of the case on the economic duress. Now, one can see why an English court might say that the second threat to annihilate the country is not a suitable one for it to determine. To say it is irrelevant to the question of the vitiation of true consent cannot be right. The fundamental problem with Mr. Howard's argument is that it involves an improper attempt to shoehorn everything into the domestic foothold stage of the analysis. And in our submission, this approach subverts the proper analytical framework to which I turn next.
Where do we find, can you give us the reference in the pleadings to the threat to annihilate the country?
I was referring to the threats of military aggression. The threats to, it's paragraph 202 and following deals with the threats to the territorial integrity of Ukraine. Mr. Justice Blair's judgment summarises the defence in those regards. Probably the most convenient place to look at it.
Yes, this is referring to Mr. Glaziev's remarks. Right.
Indeed. Russia could no longer guarantee the territorial integrity or the borders of Ukraine, and that Russia will be justified in supporting separatist elements in Ukraine. Yes, my Lord Carnworth, on economic pressure, the relevant reference is paragraph 295 of Mr. Justice Blair's judgment.
Thank you.
The decision of the Supreme Court in Shergill in our submission provides the appropriate analytical framework, and the key paragraphs are 41 through to 43, which the Court of Appeal cited in full at paragraph 154 of its judgment. Perhaps we can just turn up Shergill in Authorities Bundle 3, tab 19.
Just give us an MS number.
Sorry, my lord. Yes, of course. It is MS. The case begins on MS 1256, and the relevant paragraph I'm going to turn to is MS 1273. And if we start at MS 1273 at paragraph 40, you'll see that there is reference in the judgment of Lord Newburger, Lord Sumption, and my Lord Hodge, which refers at paragraph 40 to the Butts gas case, and then just below letter G, referring to Butts gas, they say that the issue was non-justiciable because it was political. It was political for two reasons. One was that it trespassed on the proper province of the executive as the organ of the state, charged with the conduct of foreign relations. The lack of manageable judicial standards was the other reason why it was political. And then if we go, please, to paragraph 41, see just at letter D, which is MS 1274, the court says that letter D, properly speaking, the term non-justiciability refers to something different. It refers to a case where an issue is said to be inherently unsuitable for judicial determination by reason only of its subject matter. Such cases generally fall into one of two categories. And perhaps if we can start in reverse order, because paragraph 43, it's common ground, see the trustee's written case, paragraph 75 to 77. The paragraph 43 deals with relevance. And at 43, the Supreme Court says the basis of the second category of non-justiciable cases is quite different. It comprises claims or defences which are based neither on private legal rights or obligations, nor on reviewable matters of public law. Examples include domestic disputes, transactions not intended by the participants to affect their legal relations, and issues of international law which engage no private right of the claimant or reviewable question of public law. Some issues might well be non-justiciable in this sense if the court were asked to decide them in the abstract, but they must nevertheless be resolved if their resolution is necessary in order to decide some other issue which is in itself justiciable. The best known examples are in the domain of public law. Thus, when the court declines to adjudicate on the international acts of foreign sovereign states or to review the exercise of the Crown's prerogative in the conduct of foreign affairs, it normally refuses on the ground that no legal right of the citizen is engaged, whether in public or private law. You'll see references given to the CND and the Al-Haq cases, which I'll come back to. As Mr. Justice Cranston put it in the Al-Haq case at paragraph 60, there is no domestic foothold, but the court does adjudicate on these matters if a justiciable legitimate expectation or a convention right depends on it, cite Abbasi. And then this, the same would apply if a private law liability was asserted which depended on such a matter. So that addresses relevance. And then if we go back to paragraph 42...
And what is significant there is that in the context of that case, the issue whether or not someone was a spiritual leader of the sect because he was successor of the first holy saint was something that would not normally adjudicate on in the court of law. But because there was trust property at stake, that became a relevant issue.
Became necessary there.
It became necessary to determine it, and that's what is being said in that paragraph.
Exactly.
Yes.
And that's why this touches on the question of relevance and therefore domestic foothold.
Yes.
Well, I confess with great respect that I have some trouble with this passage in the sense that it sort of bundles together things as different as domestic disputes, religious disputes, and international law issues. I mean, it is actually technically all obiter, isn't it?
It is, but I think a number of courts, including the Court of Appeal, for example, in Belhard, has accepted Shergill as providing a useful analytical framework for looking at questions of just disability in both senses.
Yes, I mean, I also have some difficulty with this sort of divide between suitability and relevance, which, of course, in this case has become critical because of the question of a stay.
Yes, no, I understand.
Does that come from anywhere else than from here?
I'll come back to that. It does, yes.
Yes, but whether or not paragraphs 41 to 43 are obiter, if you look at the judgment as a whole, when you go on to the third chunk of the judgment there, you can see quite clearly from the case law that is there discussed that religious disputes are not matters for the court to determine unless patrimonial rights are at stake. And if they are, then the court must determine them.
Exactly.
And so whether or not too much is bundled into paragraph 43, the concept of relevance that's being dealt with there is the one that I think of which I speak.
Yes, quite.
Oh, yes, I mean, I don't have any difficulty at all with the case, of course, on its facts, on what it decided. Anyway, there we are.
I appreciate a number of issues are bundled up there, but it is highly relevant to the issues that we have to consider for these purposes. And then if one goes back to...
It rather reads as though the distinction that seems to be drawn is between matters which, on the one hand, matters which the court will never determine because they are inherently unsuitable for judicial determination, and on the other hand, matters which the court will determine if a legal right depends on it.
Yes, I'm going to come to that because that's where you have the interplay between paragraph 43 and 42. So I would accept that there are some cases in which there is a domestic foothold, which are relevant, but fall within paragraph 43, which are nevertheless beyond the competence of an English court to determine. So it's not a complete answer to say it's relevant, therefore the court has to determine it. The court will try and determine it, and it's required to determine unless it is incompetent to do so.
Yes, but I mean, I'm not sure the language of suitability and relevance is really terribly helpful if the distinction is the one that I've suggested. I mean, for example, the Foreign Act of State doctrine would suggest that if you're in the scope of that doctrine, the court is never going to adjudicate on the issue.
Well, it depends on lots of factors, including, for example, whether the public policy exception applies. So it's not quite as simple as saying, well, if Foreign Act of State is engaged, the court can't determine it. It all depends. And there are cases where the court will look at Foreign Act of State, issues which are prima facie Foreign Act of State issues. For example, if the public policy exception applies, and there are obviously other exceptions as well.
Yeah.
But all I'm on at the moment on 42...
The point being made in 42 between G and H is that the distinctive feature of all these cases is that once the forbidden area is identified, the court may not adjudicate on the matters within it, even if it's necessary to do so in order to decide some other issue.
Right. But I'm trying to separate out two different points. One is whether there's a domestic foothold in the sense of relevance.
Well,
and secondly, whether...
What's meant by relevance?
Relevance is whether there is an issue raised which is justiciable, here, the validity of the contract, to which an international law issue is relevant.
That sounds circular. Relevance is whether an issue raised is justiciable. Justiciability depends on whether the matter is characterised as one of relevance.
Yes, I understand that so far as relevance and domestic foothold is concerned, it is a question of whether there is an issue which the English court is required to determine to which the international law issues are relevant. And what 42 goes on to look at is that there are nonetheless some issues which, although relevant, the English court will not look at because it's beyond their competence. And Butts is cited as a classic example of that. But it doesn't mean there's no domestic foothold, and it doesn't mean it's irrelevant.
Yes, so identifying a domestic foothold doesn't resolve the issue.
No. It doesn't.
I mean,
it doesn't,
what the issue actually turns on, rather sounds to me at the moment, is whether you're within 42, which depends on whether, as a matter of a separation of powers, the issue is one which the courts are constitutionally appropriate to decide.
Right. But that doesn't kick away the domestic foothold in the first place. It might mean that although there's a domestic foothold, the court will not look at it because it's beyond its competence, constitutionally or otherwise. But it doesn't mean there is no domestic foothold. Mr. Howard's case attempts to shoehorn everything into domestic foothold, whereas what we have developed in this country is a more sophisticated doctrine of foreign act of state, which has various balances and checks, exceptions and so on, including where something is relevant, that a stay may be appropriate because you can't have a fair determination of the issue, because the English court is not competent to determine a defence. And that's what paragraph 42 makes clear. So if we look at 42, if I may, what Lord Neuberger and Lord Hodge and others say is that the first category comprises cases where the issue in question is beyond the constitutional competence assigned to the courts under our conception of separation of powers. Cases in this category are rare, and rightly so, for they may result in denial of justice, which could only exceptionally be justified either at common law or under Article 6 of the Convention. The paradigm cases are the non-justiciability of certain transactions of foreign states, i.e. foreign act of state doctrine, and then proceedings in Parliament which we don't need to concern ourselves with. The first is based in part on the constitutional limits of the court's competence, as against that of the executive in matters directly affecting the United Kingdom's relations with foreign states. So far as it's based on the separation of powers, Butts is the leading case in this category, although the boundaries of the category of transactions of states, which will engage the doctrine, now are a good less clear today than they seemed 40 years ago. And then he deals with parliamentary privilege, and then just between letter G and H, so the distinctive feature of all these cases is that once the forbidden area is identified, the court may not adjudicate on the matters within it, even if it's necessary to do so in order to decide some other issue which is itself unquestionably justiciable. And then this, where the non-justiciable issue inhibits the defence of a claim, this may make it necessary to strike out an otherwise justiciable claim on the ground that it cannot fairly be tried. So one does need to separate out these two concepts, and we, for our part, accept that there are some cases where there is a domestic foothold, see paragraph 43, which are nevertheless beyond the competence of an English court to determine, and that's paragraph 42. And Butts,
presumably you would say Butts is such a case.
Butts, I was going to say Butts is a classic example of that concept, and I'll come back to the way the Court of Appeal deals with Butts in a moment. And critically, you see, where the non-justiciable issue inhibits the defence to a claim, it may make it necessary to strike out, or in this case, the Court of Appeal said stay, an otherwise justiciable claim on the ground that it cannot fairly be tried. Now, against that backdrop, in our submission, the Court of Appeal's approach cannot be faulted. If one goes to the Court of Appeal in Court Volume 2, MS 8669.
Sorry,
8669
Okay.
is the MS number, and the bundle number is page 61.
Paragraph?
Paragraph 155.
Thank you.
And so, paragraph 155, Lord Sales, speaking for the Court of Appeal, and he's just looked at Shergill, set out the paragraphs we've just looked at in paragraph 154. And at paragraph 155, he says, in the light of these observations and taking paragraph 43 and 42 of Shergill in reverse order, 3 issues arise in relation to Ukraine's duress defence under ground 2. Issue 1, is there a domestic foothold? That is to say, a basis in legal analysis under English law, which requires or permits the court to embark upon an examination of Ukraine's case that Russia made threats against it, which were unlawful as a matter of international law or otherwise illegitimate. And then issue 2, if there is a domestic foothold, is the issue nonetheless beyond the competence of the English courts to resolve? So you see issue 1 addresses paragraph 43 of Shergill, issue 2 addresses paragraph 42. And then issue 3 over the page, if there is a domestic foothold but the issue is beyond the competence of the English courts to resolve, should the court grant an unlimited stay of proceedings or strike out Lord Debenture's claim, which is a claim to vindicate Russia's rights as lender under the notes, because as a result its claim under the notes cannot fairly be tried. And then, so that 3-stage approach, we say, is completely appropriate and in line with the framework set out in Shergill. And if we go on to paragraph 159, it says, in our judgment, Ukraine succeeds in showing there's a domestic foothold for the purposes of issue 1 in relation to the issue of illegitimate pressure. English law provides that a contract made as a result of illegitimate pressure will not be enforceable. Ukraine appeals to this substantive doctrine of duress in English law in its defence to Lord Debenture's claim on the notes. It's common ground that for the purpose of the application of summary judgment, although Lord Debenture reserves full argument on the point for trial, any relevant duress arguably exerted by Russia may be taken to affect the contractual rights relied upon by Lord Debenture, and hence would provide Ukraine with an arguable defence against Lord Debenture in suing on the notes. In our view, given the relevant concession for the purpose of the summary judgment application, Ukraine is entitled to seek to rely on this doctrine of domestic law in its defence for the purpose of resisting that application, and having done so, the court has to examine that defence to see if it's made out. This provides a sufficient foothold in English law at the stage of issue 1. And then at paragraph 160, paragraph you were taken to yesterday, it's true that Russia and Ukraine are sovereign states, which means that the test for what might count as morally or socially unacceptable in the context in which they interact with each other is not the usual one, appropriate relation between private parties, but the authorities make it clear that the English law doctrine of duress does not turn on breach of domestic law as a criterion for illegitimate pressure. The notion of illegitimate pressure is wider than that, and then perhaps you could read to the end of that paragraph.
Can I ask just to be clear, you read out in paragraph 159 at the foot of a page and just onto the next page the area of common ground, that for the purposes of the application, any relevant duress arguably exerted by Russia may be taken to affect the contractual rights relied on. By the words, any relevant duress, are we to understand that as meaning any actions by Russia which would constitute duress for the purposes of English law?
I think it simply means acts which are capable of constituting duress, i.e. illegitimate. You see that they are applying the substantive doctrine of duress in English law.
Might be said, Mr. Thankey, those closing words of paragraph 160 reintroduce the question of the lawfulness of the conduct. It is said against you. That's what happens.
Yes, I mean, they plainly took into account whether Russia should be granted some sort of greater latitude given its estate, and whether there are standards in international law which would attenuate the conduct that would be expected of Russia in relation to the law of duress. So in that sense, this was applied to Russia's benefit to see if English duress principles were appropriate to apply to a state where a contract is procured by the use of threats.
If, as you suggest in your written case, international law standards are to inform the application of the domestic law test, then it might be that that brings in the whole question as to the legality of the conduct in international law.
Yes. I don't shy away from the fact that English law is entitled, particularly in developing public policy, which is an important consideration in the law of duress, in drawing on international law, in assessing appropriate standards of English public policy, which is a fairly modest use of public international law in our submission. So it's perfectly appropriate to draw from international law in judging the appropriateness or otherwise of Russian conduct. And one sees that is what the Court of Appeal effectively did in this case. But what they're saying is it's not purely a matter of what is legal or illegal as a matter of domestic English law. In testing illegitimacy, one can have regard to public international law, and particular concepts of public policy in international law. And one sees the common law being developed all the time by reference to international public policy, and one sees that being done in Kuwait, which we'll come to, and in Belhaj, which we'll come to.
Thank you.
And then at paragraph 161, your lordships will see that the Court of Appeal says, Mr. Howard submitted that a domestic court has no authority to rule upon whether a foreign state has violated its obligations under international law. And this is a matter so remote from the court's competence that it could not be said that allegations of such violation could give rise to any issue in domestic law. We disagree. In our view, this submission confuses issue 1 and issue 2 and is appropriately addressed in the context of issue 2. In relation to issue 1, the submission is contrary to authority. And in our submission, the Court of Appeal's approach there is correct. Domestic foothold, i.e. relevance, is a distinct and separate stage in any analysis of justiciability. It's wrong in principle to allow questions of suitability to swallow up the question of foothold or relevance. And the Court of Appeal was right to reject such an argument. If you go over the page to paragraph 163 at MS 8672, the Court of Appeal says the formulation of principle by the Supreme Court in Shergan expressly indicates that there may be a relevant foothold in domestic law in relation to issue 1 in a case involving issues of international law. This is contrary to the suggestion by Mr. Howard that the mere fact that an issue of international law is raised by Ukraine in support of its defence in the present case shows that there is no domestic foothold. In our submission, the Court of Appeal was right to reject such an argument. And what one sees happening here is that the trustee hopes that by defining the scope, by saying that it's defining the scope of any permissible defence, i.e. relevance, rather than putting its argument as one of suitability, it will be able to evade the problems with its non-justiciability case identified by the Court of Appeal, and crucially, avoid a stay. So the belated concessions on suitability made for the first time in the Supreme Court are, in our submission, tactical. And needless to say, the trustee seeks to shoehorn many of its old suitability arguments back in through the medium of domestic foothold. As the Court of Appeal said, that approach confuses two different concepts at paragraph 161 we've just looked at. Domestic foothold and justiciability in the sense of suitability require separate consideration. Otherwise, suitability would completely consume the concept of relevance, and that's the point being made by the Court of Appeal at paragraph 163.
Can I ask why you why it's necessary to bring in international law at all? Why you don't simply say as a matter of fact, Ukraine's, the relevant people acting on behalf of Ukraine's will was overborne by pressure exerted by Russia, economic pressure, threat of force, and so forth, and leave it to as a matter of adjudication by an English court whether that constitutes illegitimate pressure for the purposes of the law of duress.
Yes. I could do, and that is my fallback position, if the court is against me that international law can provide a relevant yardstick for illegitimacy. That would be my fallback position.
And I'm wondering in a way why we haven't looked at the English law of contract and what constitutes illegitimate pressure, but I'm wondering why international law really comes into it.
The way in which the Court of Appeal used it was really as a cross-check to see if English law principles were appropriate as applied to a state, and they found no justification effectively in international law for Russian conduct. And that's the way in which essentially the Court of Appeal used the concept of considered international law to be relevant. But it would be perfectly possible to say that in a sense threats of aggression are a paradigm case of duress as a matter of English law, and one doesn't need to have regard to English law.
Well, I mean, the way the Court of Appeal approached it in 160 was to treat international law as setting out standards of conduct applicable between states, and according to them, there's no reason why the law of duress shouldn't treat these as providing an appropriate test of illegitimate pressure. So what they're saying is that the English law of contract would treat the issue of whether international law had been violated as an appropriate test of whether there was illegitimate pressure.
Yes. I think partly because it's difficult to judge states' conduct other than through public international law. But one could simply have resort to English law principles and English public policy and say, are these tests, are these threats appropriate or not, and are they capable of vitiating true consent?
Yes, and on that approach, if it was arguable that there was a breach of international law, that would be more than sufficient for your purposes. You wouldn't need a ruling that there was a breach.
No, precisely, at particularly a summary judgment stage. And if Russia chooses an English contract, it must comply with English standards of behaviour. So, just focusing on domestic foothold, so far as domestic foothold is concerned, there must be an issue. There must be an issue in private legal right or an obligation or a reviewable matter of public law. In Mr. Justice Cranston's phrase that he used in El Haq, that is the domestic foothold. We agree it is essentially a principle of relevance. The courts don't decide hypothetical disputes. They will not consider any matter that does not form part of a genuine list based on a domestic law cause of action or defence. And that requirement in Belhaj was satisfied by a claim in tort. And in the present context, domestic foothold means no more than the assertion of a private law right, which is justiciable by the English courts, to which consideration of an international law issue is relevant. See Shergill, paragraph 43. And in instructing the trustee to bring this claim before our courts, Russia asserts the validity of an English law-governed contract. Validity of that contract is challenged by the defence of duress, under which Ukraine says that it has avoided the contract. The contractual claim and the defence of duress provides an obvious foothold in our submission. Once a domestic foothold is established, the question is then whether the Foreign Act to State doctrine should bar the claim or defence from being adjudicated on by the English courts on the grounds of suitability. Now, below it was common ground that the potentially relevant rule in this context is Lord Neuberger's third rule in Belhage in terms of suitability. And perhaps we could just take a quick look at Belhage and Authorities 1. Authorities 1, beginning at MS page 18, and it's a paragraph 123 at MS 165. Just wanted to go back to. You see at paragraph 121, Lord Neuberger spoke for the majority in Belhage in the Supreme Court. And he deals at 121 with the first rule, 122 with the second rule, and then the rule we're concerned with 123, the third rule. Third rule has more than one component, but each component involves issues which are inappropriate for the courts of the United Kingdom to resolve because they involve a challenge to the lawfulness of the act of a foreign state, which is of such a nature that a municipal judge cannot or ought not to rule on it. Thus, the courts of this country will not interpret or question dealings between sovereign states. Obvious examples are making war and peace, making treaties with foreign sovereigns and annexations and cessions of territory. And this is the paragraph that the Court of Appeal cites at paragraph 170 of its judgment. And then at the next page, similarly, the courts of this country will not, as a matter of judicial policy, determine the legality of acts of foreign government in the conduct of foreign affairs. So it's also part of this third rule that international treaties and conventions should not become incorporated into domestic law, cannot have the source of domestic rights or duties, and will not be interpreted by our courts. This third rule is justified on the ground that domestic courts should not normally determine issues which are only really appropriate for diplomatic or similar channels. And you'll see that Lord Neuberger cites Shergill, the Shergill case there. It's going to the third rule. And interestingly, he cites Shergill paragraph 42. 40 and 42. 40 deals with the Butte's gas case. 42 deals with the suitability paragraph in Shergill. Does not cite paragraph 43 in Shergill, which deals with domestic foothold and relevance. So the third rule, one can see, goes to competence or suitability, not to relevance. It's a separate matter. Now, there is no answer in the trustee's written case to the Court of Appeal's closely argued reasons as to why the case is suitable for determination, notwithstanding the Foreign Act to State doctrine, rejecting the trustee's case as advanced below, or, if it is not suitable, why it should be stayed. The trustee says all of those reasons given by the Court of Appeal are irrelevant, as the only issue they pursue before this court is the domestic foothold or relevance question. See trustee's written case, paragraphs 155 to 156. And we don't see an answer from the trustee to the reasoning on English public policy, appropriately drawing on international law and setting appropriate standards of behaviour, which the Court of Appeal makes at paragraph 180 of its judgment. Now, one just needs to consider the consequences of this. It seemed to be accepted by Mr. Howard yesterday that if a senior Russian official at the direction of the President procured the contract by threatening to assassinate the Ukrainian finance minister or her family, that would be duress in English law. It's accepted that that would be illegitimate, even if it's done for reasons of high state or political reasons. Mr. Howard has no difficulty in accepting that such conduct would be improper and would deflect consent to the contract, making it avoidable. It appears Mr. Howard also accepts that if Russia made threats to breach another contract, for example, for the supply of gas, the disruption of which would lead to people freezing in Kiev in the winter, that would be capable of being economic duress. Again, even if the breach of contract occurs at the direction of the Kremlin for reasons of state. But, he says, if the gas is supplied under a treaty identically worded to the contract, the court is required not just to ignore the factual threats made, but to give effect to them by enforcing the contract procured by threats. Equally, if Russia, instead of threatening the lives of a few people, the Minister of Finance and her family, threatened to bomb a Ukrainian city, killing thousands, that would apparently not be duress, because that's a matter of war and peace, which is not recognised as being within the scope of illegitimate conduct under English law. So the more serious the threat, and therefore the more effective the threat used to procure the English law contract, the less willing the English courts, English law will be to recognise its existence, and according to Mr. Howard, simply enforce the contract. But in our submission, the fact that conduct relied on is also a breach of international law does not somehow kick away the domestic foothold. These issues are better approached not by redefining duress so as to narrow any available domestic foothold, but by ascertaining which issues are suitable for the English court to determine. Suitability is an exercise which balances a number of factors, which the Court of Appeal addressed with care, none of which have been challenged in writing or orally by the trustee. Suitability recognises that there are in truth no absolute no-go areas, CQ8, see Belhage, which we'll come to. But there are areas where a very higher or lesser degree of abstention may be appropriate depending on the exact circumstances. Indeed, the trustee has now accepted that this case is suitable for determination, does not therefore say there are no judicial or manageable standards. And the suitability test provides fair and sophisticated remedies if a case is not suitable for determination. Those remedies include a stay, which Mr. Howard did not contest if a domestic foothold were established. Now, can I then turn to the concept of domestic foothold and its proper limits? We say that the domestic foothold here is simple, an English law contract under which the parties have putatively agreed to submit disputes to the English courts. It's common ground that duress is available as a defence to a claim in contract. See Court of Appeal, paragraph 159. We've shown the way this issue was addressed by the Supreme Court in Shergill at paragraph 43. In a nutshell, the common law courts do not like deciding abstract issues or giving advisory opinions. Still less do they like to do so when they perceive they're being asked to give advisory opinions on questions of international law. But as Shergill demonstrates, the position is very different where there is a relevant right requiring determination to which the international law issue is relevant, so far as domestic foothold is concerned. In our submission, if the international law issues do fall for determination in considering our duress defence, then they should be determined given the firm domestic foothold. If they cannot be determined due to lack of competence or unsuitability, then, as in Butts, the only fair outcome is a stay. Here the trustee's claim is for breach of contract, brought as of right in the English courts. There is a list between the parties, including whether the contract forming the basis of the claim has been avoided for duress. Contrary to the trustee's case, Ukraine's defence does not involve the destruction of a right held by the trustee. That analysis wrongly assumes that the trustee has an unqualified right to enforce the contract, as opposed to a right that is contingent on the contract being valid, including whether it's voidable for duress. And the Butts gas case is a formidable roadblock in the way of Mr. Howard's argument on domestic foothold. Mr. Howard took you to the Butts case itself yesterday, but can I take you to the way the Court of Appeal in this case dealt with it? Because in our submission, its reasoning is impeccable. If we go, please, to Core Volume 2, MS 8671, page 63 of the bundle. And at paragraph 162, Lord Sales says, in Butts, the claimant sued the first defendant for defamation in relation to statements made by him to the effect that the claimants had conspired with the ruler of Sharjah for Sharjah to make unjustified territorial claims in respect of an oil field in the Persian Gulf, and then award oil concessions in respect of it to the claimants, thereby cheating the first defendant's company, second defendant, out of an oil concession in respect to the same field granted by a neighbouring state, Kuwait, which also laid claim to it. The pleaded defences were justification and fair comment. Defendants also counterclaimed for damages for alleged conspiracy between the claimants and the ruler of Sharjah and others to treat and defraud them, relying on the same pleaded allegations as for their defences of justification and fair comment. The issues raised covered a range of matters, including competing claims to the oil field by a range of states and the conduct of international relations by the United Kingdom government in pursuit of its strategic interests. The House of Lords held that the domestic court should abstain from deciding the issues raised for reasons of non-justiciability related to issue 2 above, that's suitability above, and that all proceedings on the claim and on the counterclaim should be stayed as a result. Thus, far from saying that the defence of justification could not be raised at all on the grounds of an absence of domestic foothold under issue 1, so that the claim in defamation must inevitably succeed, the House of Lords regarded the appropriate outcome as being one that the claim should be stayed. As Lord Wilberforce said, noting that the defendant's plea of justification could not be entertained by the court, to allow the claimant's libel action to proceed but deny the defendants the opportunity to justify would seem unjust. Lord Wilberforce made this point, although as it transpired, the House of Lords did not have to decide that issue because the claimants had offered to submit to a stay of their libel claim if the counterclaim was stayed, and the House of Lords held them to that offer. So one sees that there is no need to incorporate public international law into English law to make it relevant to the defence. If the trustee is correct, Butts was approached on an incorrect basis by the House of Lords, and there should not have been any consideration of a stay. What the appellate committee should have done was to modify the principles of the law of defamation to find that there was no domestic foothold, to preclude a defence of justification where the relevant allegedly untrue statement involved a question of international law. That would have meant that the claims would all have inevitably succeeded and not been stayed. Now, the trustee's only response to Butts is to suggest that defamation is some sort of sui generis category, which does not apparently require incorporation of English law, of international law. See their written case at paragraphs 70 to 71. But in our submission, the Court of Appeal was quite right to treat Buttes in the way that it did, as providing a formidable obstacle to the way in which the trustee puts its argument on domestic foothold. Now, one sees that the trustee's argument is heavily reliant on the case of Crown and Margaret Jones, and perhaps we can look at that to look at it in proper context. This is in Authorities Volume 3, tab 14. Now, in our submission, Jones, it's MS page 984. In our submission, Jones was not a domestic foothold case at all, but an exercise in statutory construction. And in our case, ultimately the case is irrelevant to the issues now before the court, but it's necessary to deal with it given the reliance placed on it. If one just looks at the head note, one sees there are two sets of appeals. In the first set of appeals, the defendants were charged on an indictment containing various counts related to criminal damage at an operational military airbase. By way of defence, they asserted that the United Kingdom's actions in preparing for, declaring and waging war in Iraq were unlawful acts, which they were justified and attempted to prevent by the use of reasonable force under Section 3 of the Criminal Law Act, 1967. In the second set of proceedings, beginning just below letter F, the defendants in two cases were involved in activities at military bases in protest against the Iraq War, charged with aggravated trespass contrary to Section 68 of the Criminal Justice and Public Order Act 1994. They'd entered on and obstructed or disrupted lawful activities on the land. Defendants denied the charges and asserted that the activities at the bases were unlawful since they were carried out in pursuit of an unlawful war of aggression and constitute a war crime under the 2001 Act. In relation to charges brought against some of the defendants of criminal damage, contrary to Section 1 of the Criminal Damage Act 1971, they claim that they are entitled under Section 3 of the 1967 Act to use reasonable force to prevent the crime of aggression. One sees, when one looks at the judgments, the court was effectively being asked to expand the scope of the relevant statute in a way that would have effectively required the court to give an advisory declaration as to the lawfulness of UK actions in an armed conflict under international law, and create a novel type of defence to a criminal charge. If we go first to the speech of Lord Bingham, MS 1003, Lord Bingham deals with the issues arising under several headings. Issue 1, Mr. Howard took you to yesterday. Issue 2, page 1003, letter G, at all times relevant to these appeals, customary international laws recognise a crime of aggression. And if we could go on, please, to paragraph 18. You'll see references made there. I'll ask you just to note to the Nicaragua decision in the ICJ, which, if time permits, I will come back to. And at paragraph 19, Lord Bingham says that it was suggested on behalf of the Crown that the crime of aggression lacked the certainty of definition required of any criminal offence, particularly a crime of this gravity. And then at the foot of page 1005, he says, the core elements of the crime of aggression have been understood, at least since 1945, with sufficient clarity to permit the lawful trial and on conviction punishment of those accused of this most serious crime. It's unhistorical to suppose the elements of the crime are clear in 1945, but have since become in any way obscure. So that's his conclusion on issue 2. Issue 3, page 1006, letter B, crimes recognised in customary international law are without the need for any domestic statute or judicial decision recognised and enforced by the domestic law of England and Wales. We see the way he concludes this. Paragraph 23 on page 1007 says, I would accept that a crime recognised in customary international law may be assimilated into the domestic criminal law of this country. But then, still in the same paragraph, but at page 1008, between letters B and C, Lord Bingham says that he respectfully agrees with the observations of Sir Franklin Berman in an article that he cites at length, but we can go to the end between letters F and G. He says there are powerful reasons of political accountability, regularity and legal certainty for saying that the power to create crimes should now be regarded as reserved exclusively to Parliament by statute. So that's issue 3. Issue 4, crime in section 3 of the 1967 Act covers a crime established in customary international law, such as the crime of aggression. And then if we go over the page to paragraph 26, you'll see that Lord Bingham at page 1009 says that the main object of the 1967 Act was to amend the law of England by abolishing distinctions, etc. And you see, just below letter G, the focus of the Act, the 67 Act, is entirely domestic. And it would seem to me very highly unlikely that Parliament understood crime in section 3 as covering crimes recognised in customary international law, but not assimilate into our domestic law by any statute or judicial decision. He's talking about crimes here. And then section issue 5, alternatively, crime in section 3 means a crime in the domestic law of England and Wales, and the crime of aggression is such. In paragraph 28, Lord Bingham says the lack of any statutory incorporation is not, however, a neutral factor for 2 main reasons. The first is there now exists no power in the courts to create new criminal offences, as decided by a unanimous House in Nulla. While old common law offences survive until abolished or superseded by statute, new ones are not created. Statute is now the sole source of new criminal offences. Second reason is that when it is sought to give domestic effect to crimes established in customary international law, the practice is to legislate. And paragraph 29 says these reasons taken together are very strong grounds for rejecting the appellant's contention, since they reflect what has become an important democratic principle in this country. It's for those representing the people of the country in Parliament, not the executive and the judges, to decide what conduct should be treated as lying so far outside the bounds of what is acceptable in our society as to attract criminal penalties. One would need very compelling reasons of departing from that principle. And he says in 30 that there are compelling reasons of not departing. Mr. Howard took you to the rest of paragraph 30. But at paragraph, he didn't read a paragraph in the same paragraph at page 1011, letter C. I do not suggest that these rules admit of no exceptions, cases such as Oppenheimer and Catamol and Kuwait Airways may fairly be seen as exceptions, nor in the present context is the issue one of justiciability to which many of these authorities were directed. In considering whether the customary international law of aggression has been or should be tacitly assimilated into our domestic law, nonetheless very relevant, not only that Parliament has so far refrained from taking this step, but also that it would draw the courts into an area which in the past they have entered, if at all with reluctance and the utmost circumspection. So one sees that cases such as Kuwait Airways are cited and distinguished. And Lord Bingham was careful not to say anything about how non-justiciability arguments might be resolved in the civil law context. And just for the sake of completeness, one can see issues 6 and 7 on that page and the following page, dealing with the 1994 Act, are resolved in the same way for essentially the same reasons. And then if we go, please, to Lord Hoffman at MS page 1017, again, both Lord Bingham and Lord Hoffman commanded the majority of the House of Lords in this case. The other law lords agreed with both of their judgments. Paragraph 54, Lord Hoffman says, I think it's clear that crime in section 3 means a crime in domestic law. And then if we go to the next page, 59, beginning of paragraph 59 at page 1018, Lord Hoffman says, I say nothing about the reception into English law of rules of international law which may affect rights and duties in civil law. And he goes on at 67, don't need to dwell on it, that the focus of the 1967 Act was domestic facing. And then finally, if we could look at Lord Mance, MS page 1027, paragraph 100, Lord Mance says it's unnecessary to consider the recognition or reception of international law in the context of civil law. In Kuwait Airways, the courts refused in civil proceedings to recognise an expropriatory decree made in the context of armed aggression by Iraq designed to extinguish Kuwait's existence as a separate state. So, with great respect, Jones does not assist this court in the deciding the issues before it. Essentially about the construction of the 1967 Act. Now, the trustee also relies on the case of Gentle. We can turn to that in Authorities Bundle 2. MS 954, it's tab 13. Just to, I'm sorry, my lord, paragraph, tab 13, in Authorities Bundle 2. And just to summarise, the head note, the mothers of servicemen killed in the Second Iraq War sought to rely on Article 2 of the Convention to obtain a public inquiry into whether the government had properly considered the legality of the war as a matter of international law. And the House of Lords decided that there was no domestic foothold because Article 2 contained no such obligation. Nothing in the Article 2 right gave rise to the right to such an inquiry, i.e. there was no enforceable legal right to require an inquiry. It's a very different situation in our submission to the very firm foothold provided in our case by the contract claim brought as of right in the proceedings before the English courts. The starting point is Mr. Sumption's submissions for Her Majesty's Government at page 959, MS number. one looks at the foot of the page between letters G and H, Mr. Sumption, Mr. Sales and Ms. Stratford say, the Court of Appeal decided this matter on the simple ground of non-justiciability. There are two different ways in which that term is used, judicial forbearance and lack of legal relevance. In this case, the only sense in which non-justiciability occurs is lack of legal relevance. The political nature of the decision at issue, the government's handling of international relations, is the reason why the Convention should not provide a platform for the claimants to challenge it. A government decision to engage in military operations does not engage the substantive duty under Article 2, and consequently there is no right to have the decision investigated. And the House of Lords effectively accepted this analysis. If one goes in the speech of Lord Bingham, paragraph 6, Paragraph 6, he says it's the procedural, at page 964, it is the procedural obligation under Article 2 that the claimants seek to invoke in this case. And then he says, having cited some authorities, that the procedural obligation under Article 2 is parasitic upon the existence of the substantive right and cannot exist independently. Thus, to make good their procedural right to the inquiry, the claimants must show, as they accept, at least an arguable case that the substantive right arises on the facts of these cases. Unless they can do that, their claims must fail. And he says at 8, it may be significant that Article 2 has never been held to apply to the process of deciding on the lawfulness of a resort to arms, despite the number of occasions in which member states have made that decision over the past half-century, etc. And then if one looks at, over the page at 965, between letters C and D, and this is the passage cited in Shergill, the following passage: it must further have been obvious that such an inquiry such as the claimant's claim would be drawn into consideration of issues which judicial tribunals have traditionally been very reluctant to entertain, because they recognise their limitations as suitable bodies to resolve them. And then this is what is quoted in Shergill: that is not to say that if the claimants have a legal right, the courts cannot decide it. Defendants accept that if the claimants have a legal right, it's justiciable in the courts. They do not seek to demarcate areas into which the courts may not intrude. But what the House of Lords held was that there was no substantive legal right engaged. And then Lord Hoffman at paragraph 16, page 967, unless Article 2 creates a duty not to go to war, contrary to the United Nations Charter, proposition for which, as I have said, Mr. Singh does not contend, I cannot see how there can be an independent duty to use reasonable care to ascertain whether the war would be contrary to the Charter or not. And then, if we go please to paragraph 24, Lord Hope agreed, paragraph 25, page 970, letter G, Lord Hope says, as Mr. Sumption pointed out at the outset of his argument, one must be careful to distinguish between cases where the question is whether judicial restraint ought to be exercised, and cases where the matter at issue is legally irrelevant. In this case, the question of international law falls into the latter category, i.e. legal irrelevance. The simple matter of lack of any relevance in domestic law, in other words, a lack of domestic foothold for the argument. And without taking you to it, can I, in this context, draw your attention to a speech by Lord Sumption, extrajudicial speech made by Lord Sumption explaining Gentle, which may be of assistance, but I'm not going to turn it up. But it's in our written case, we cite it at paragraph 61 of Ukraine's written case, Call Volume 1, MS 8569. By contrast, in our case, there is no doubt that there is a right to bring the claim in an English law-governed contract before the English court. There is no dispute that Ukraine has a defence of duress which may be taken to affect the contractual rights asserted and provide Ukraine with an arguable defence. See Court of Appeal paragraph 159. It is that domestic foothold to which issues of international law may be relevant. It's a very different question to whether a substantive obligation was to be implied into Article 2. Now, there are often serious issues in public law cases about whether there is a proper domestic foothold to consider the conduct of a foreign state. Commonly there is not, where the court is being used as a vehicle to obtain an advisory declaration about the conduct of armed conflict. CND and Al-Haq are good examples of this type of case where there is no proper domestic foothold. And just briefly looking at CND, same authorities, volume 2, tab 11. We don't need the head note. Go please to page 889. Paragraph 2 of the judgment of Lord Justice Simon Brown, one sees what was being asked for. What the applicant and CND seek by this judicial review application is solely declaratory relief. An advisory declaration as to the true meaning of Resolution 1441, more particularly as to whether it authorises states to take military action in the event of non-compliance by Iraq with its terms. CND submit it does not. In short, the court is being invited to declare that the UK government would be acting in breach of international law were it to take military action against Iraq without a further resolution. It is to say the least a novel and ambitious claim. And then paragraph 15. Paragraph 15 at page 895, Justice Simon Brown says, "Come therefore to preliminary issues now before us, justiciability from maturity and standing." The principle of these, of course, is justiciability, although the present question might perhaps best be formulated simply thus: should the court in its discretion entertain the substantive application? It is not, of course, a challenge. No decision is impugned, neither an existing decision nor even a prospective decision. CND must inevitably recognise that any future decision to take military action would plainly be beyond the court's purview. It is nakedly an application for an advisory declaration. The court's jurisdiction is to grant relief in this form, rarely though its exercise cannot be doubted. And then we go please to paragraph 36 at page 903. Paragraph 36 says, should the court declare the meaning of an international instrument operating purely on the plane of international law? In my judgment, the answer is plainly no. All of the cases relied upon by the applicants in which the court has pronounced upon some issue of international law, cases where it's been necessary to do so in order to determine rights and obligations under domestic law. And then he refers to Abbasi at page 904. True it is that in Abbasi, the court recognised the breach of fundamental human rights constituted by the denial to all detainees of access to a court to challenge the legality of the detention. But as already pointed out, the court carefully refrained from considering the legality of the detention itself throughout its concern solely with Mr. Abbasi's rights under domestic law, then his right to have the Foreign Secretary properly exercise discretion whether, and if so how, to assist the applicant as a British citizen. And then Abbasi, indeed, so far from affording support to the applicant's argument, in my judgment, tends rather to undermine it. And then he refers to Lander and Kebeline, likewise were cases in which the courts were prepared to examine the position under an international convention, but only in the context of reviewing the legality of a decision under domestic law. Mr. Sales points out, there is in the present case no point of reference in domestic law to which the international law issue can be said to go. Nothing here susceptible of challenge in the way of the determination of rights, interest or duties under domestic law to draw the court into the field of international law. And at 40, one sees at letter F, page 905, here there is simply no foothold in domestic law for any ruling to be given on international law. And then paragraph 47, one sees its conclusions. Subparagraph 1, the court has no jurisdiction to declare the true interpretation of an international instrument which has not been incorporated into English domestic law, and then this, and which it is unnecessary to interpret for the purposes of determining a person's rights or duties under domestic law. And that passage was applied in the Ecuador and Oriental case, where it was necessary to determine a person's rights or duties, and without turning it up. Paragraph 31 of Ecuador and Oriental, A15, tab 143, MS 6116.
Sorry, could you give the reference again, please?
Sorry, my lord. Paragraph 31 of Ecuador, Authorities 15, tab 143, MS 6116.
Thank you.
And then at 2, the court would in any event decline to embark upon the determination of an issue if to do so would be damaging to the public interest in the field of international relations, national security or defence. No such issue arises in this case. And then paragraph 49, in judgment of Mr. Justice Morris Kay, page 908, notes that there is no challenge to an existing decision and the only remedy sought is a declaration of advisory nature. And then at paragraph 61, in the judgment of Mr. Justice Richards, page 913, further objection to the claim is that it asks the national courts to declare the meaning and effect of an instrument of international law. And he says, 1, the basic rule is that international treaties do not form part of domestic law and that the national courts have no jurisdiction to interpret and apply them. And then at letter 3, little Roman 3, by way of exception to the basic rule, situations arise where the national courts have to adjudicate upon the interpretation of international treaties, for example, in determining private rights and obligations under domestic law. And just with CND in mind, could I just ask the court to look at Serdar Mohammed, where Lord Sumption deals with CND at Authorities Bundle 12. It's tab 109.
Page?
If we go to MS 4570, please. That's the beginning of the judgment, and then specifically Lord Mance at 4732, please, my lord. If you have that, paragraph 79, Lord Sumption says, non-justiciability is a treacherous word, partly because of its lack of definition, partly because it's commonly used as a portmanteau term encompassing a number of different legal principles with different incidents. Strictly speaking, as this court observed in Shergill, it should be reserved for cases where an issue is said to be inherently unsuitable for judicial determination by reason only of its subject matter. This may result in a court declining to determine an issue notwithstanding its relevance to the dispute between the parties, for example, because there are no juridical standards by which to determine it, as in Butte's gas and oil, or because its determination is not within the constitutional competence of the courts, because it would trespass on parliamentary privilege, as in Preble. These are mandatory rules of public policy originating in the law's recognition of the separation of powers between different organs of the state. They define the limits of the court's jurisdiction or juridical competence. But there are other principles also originating in the separation of powers and described as principles of non-justiciability, which do not go to the court's jurisdiction or competence, but to the existence and scope of legal rights. Thus, in CND, the court proceeded on the footing that it had both jurisdiction and competence to determine whether a resolution of the United Nations Security Council authorized military operations against Iraq, but declined to do so because, amongst other reasons, there were no relevant rights, interests, or duties under domestic law. I venture to suggest that if domestic law rights, interests, or duties had been engaged, the court would not have regarded the issues as non-justiciable. And then, without spending time on it, my learned friend, Mr. Howard, took you to the Al-Haq case yesterday, which was at Authorities Volume 13, tab 126. I wasn't proposing to turn it up again, but one sees from paragraph 8 that what the claimant sought was an order requiring the UK government publicly to denounce Israel's actions in Operation Cast Lead in the construction of the wall. And one sees from the judgments of the court that no domestic law rights or obligations were engaged, and the court unsurprisingly rejected the invitation to decide the case. And in our submission, the question whether there is a valid and enforceable contract or whether Ukraine has a defence to a claim brought under that contract, and a right to avoid the contract, plainly gives rise to a domestic foothold. If there are then justiciability problems, conceptually, they're properly dealt with, as the Court of Appeal dealt with them, under the Foreign Act of State doctrine, assessing its suitability for determination by the English courts. And Foreign Act of State has a sophisticated, though developing, balancing of relevant factors and exceptions tailored for the job. And one of the problems with the trustees' submissions is that they're made under the banner of the English courts not becoming involved in a dispute between states. However, the practical reality is that the court is being invited by the trustee on Russia's instruction to make a decisive intervention in favour of Russia and to enforce and give effect to a contract allegedly procured by duress and by threats. The court is not just being asked in this case to recognise a contract arguably procured by duress. The court is being asked to give a judgment on the contractual claim based on that contract without taking into account the defence of duress, i.e. closing its ears to Ukraine's defence that its consent to the contract was vitiated by duress. And we say the objection to that approach, where you consider the claim but not the defence, is that the court is being asked to become the mechanism by which Russia's threats to Ukraine can actually be given full practical effect without a trial. What Russia seeks is very far from any traditional notion of judicial abstention. It's to permit the English court to be used as a powerfully effective tool to implement threats which are prohibited by common law and, in our submission, contrary to English public policy and, for good measure, customary international law. And as the court will appreciate, this feeds into our arguments on stay and the way the Court of Appeal approached it if the matter was unsuitable for judicial determination. And we complain that the trustee's case is effectively that the law of duress ought to be modified and restricted so as to exclude most acts of duress committed by a state on the international plane. Effectively, the request is to develop the common law to introduce a new limit on the defence of duress, narrowing the available ledge for any domestic foothold, even though that is, of course, the purpose of the existing and satisfactory foreign act of state principles. The profound public policy objections to such a development, an unscrupulous state could then demand the entry into contracts governed by English law and jurisdiction clauses with threats of aggression and rely on the English courts to enforce those threats. And London's status as a global financial centre and the trustees' contention as to the contents of English law would make English law a doubly attractive choice for such an unscrupulous state. And we say there's no justification for developing English law to allow the enforcement of a contract where the duress involves both a breach of international and domestic law principles of appropriate conduct. This case is much better approached through the prism of foreign act of state, as the Court of Appeal did in this case, not by an artificial shoehorning of suitability questions into the question of domestic foothold or relevance. Can I then turn briefly, if I may, because Court of Appeal's paragraph 157 was accepted as common ground, but the law of duress is well established as a defence to a claim for breach of contract, and duress reflects fundamental principles of English public policy, repugnant to permit a party to procure a contract by threats and then to be permitted to rely on contractual rights so obtained and then enforce them against the victim. The defence is made out, it leads to a right on the part of the victim to avoid the contract. A successful plea of duress does not leave Russia without any remedy. As the Court of Appeal noted at paragraph 152 of its judgment, Russia has potentially available to it, but has never pleaded, possible restitutionary claim, see the Haugsund case we'll come to tomorrow, subject to ordinary defences to such claims, including change of position. Such a claim enables the court to do practical justice between the parties. Now, the trustee says that a claim in restitution is not what Russia bargained for, but if the contract was procured by duress, then there is no consensual bargain. Now, the law on duress is accurately stated by the Court of Appeal at paragraph 157. If we can just remind ourselves what it says at Core Volume 2, page 62, MS 8670. One sees there, having set out the reference to progress bulk, between letters C and D, Court of Appeal says it's necessary to show that illegitimate pressure was applied, and that this pressure caused the pressurised party to enter into the contract, which he seeks to avoid. And then say that Mr. Justice Cook accurately summarised the effect of the CTN case as follows, and then between letters E and F, sees the reference to Lord Justice Sain referring to the critical inquiry as being not whether the conduct is lawful, but whether it's morally or socially unacceptable.
Now, if that's right, I again wonder how important it is whether it is lawful under international law. I've been thinking about this a little. The case we looked at yesterday of the what's it called, the
Dimskal.
Yes, something Evia Luck. There the conduct was lawful in the jurisdiction where it took place. But the court, the House of Lords said that's beside the point, because whether it's vitiated by duress is determined by the proper law of the contract. Therefore, what constitutes unlawful or illegitimate pressure is determined by the proper law. And he also said it follows that it doesn't matter where the conduct in question takes place. Some jurisdictions it might be lawful, others unlawful. That's all irrelevant. The issue is, how does English law regard this conduct? And so as one sees here, Lord Justice Steyn saying the critical inquiry is not whether the conduct is lawful. Now, if that's right, a lot of conduct by states might be lawful or unlawful under international law,
Yes.
depending on where it happened or what treaties the state happened to have entered into. But I would have thought whether it amounted to duress under English law wouldn't depend on those considerations.
Ultimately, we rely on an English law standard of duress. The relevance of international law is because English public policy is relevant to what constitutes duress. International law is a legitimate reference point for English law to have regard to in developing its own public policy. And that's the principal area in which international law is relevant in this context.
Are you saying its significance is really evidential?
Yes. Yes, one doesn't need to find, for example, a breach of a trade treaty. It would be sufficient for our purposes if trade sanctions were imposed for spurious and non-bona fide reasons. One doesn't need to look at a trade treaty to see, well, is there an entitlement to do X, Y, or Z under the GATT rules or the WTO rules? The critical inquiry is whether, is in this context, would actually be the motive for imposing the trade restrictions. And in the CTN case, which Mr. Howard took you to yesterday, the defendant effectively escaped liability and escaped. He was held not to have committed duress because he had a genuine belief that he was entitled to do what he did. So it's not critical that one has to find a breach of international law, but inevitably where one is dealing with states, it's difficult not to have regard to international law at all. But that is effectively in setting standards of appropriate behaviour, which the English court will regard as either legitimate or illegitimate.
But would that suggest that the Court of Appeal maybe went too far describing it as a test rather than a guide to what is an English law concept of what is morally and socially acceptable?
I would accept guide as an appropriate label for the task which the English court...
Well, that's why I asked you earlier about whether, if it was arguably a breach of international law. I wasn't thinking of the fact that we were at the stage of summary judgment. I was thinking that in applying the English test, one could look at the international law scene, and if this was in the territory of behaviour which was offensive to international law, that could guide an English law decision
Precisely.
as to moral and social acceptability.
Absolutely, and legitimacy and illegitimacy.
I mean, that doesn't change the nature of the inquiry, because it's not going to be much of a guide unless you can decide what international law would say about it.
Certainly international law has developed standards of behaviour for states. And yes, one does have to have a look at what...
What I'm saying is whether you call it a guide or a test doesn't really change the nature of the inquiry, does it?
Well, I wonder if it might. I mean, if, for example, you had two states behaving in the same way towards Ukraine, and one of them was party to a free trade agreement, for example, with Ukraine, and the other one wasn't, one might be in breach of its obligations under international law and the other one might not be, but whether their conduct amounted to duress might not depend on that at all.
Yes, one can have unlawful act duress, for example. One can have unlawful acts which don't constitute duress. So it's perfectly possible for there to be a breach of a trade treaty, for example, but that wouldn't amount, an English court might not regard it as duress. It's a very fact-specific
But I mean,
inquiry.
all you're saying is you can have unlawful acts which aren't duress, and you have lawful acts which are duress.
Yes,
So
absolutely.
really, where's the guide? That's what I'm trying to understand.
The reason
guide
I
is
referred to it as a guide rather than a test was that you don't need a ruling by an English court declaring that this was a breach of international
Right.
law in order to answer the English law question of duress.
By contrast, what the trustee says is truly extreme, which is that English law ignores the conduct altogether because it's conduct on the international plane, which can't be right.
We are concerned here, as I understand it, with an alleged breach of Article 2.4 of the Charter, which is recognised as the general norm
Yes.
of international law.
Yes, and Jus Cogens and Lord Neuberger in Belhage says that a breach of Jus Cogens will almost always trigger the public policy exception, even if the foreign act of state otherwise applies. A breach of any peremptory norm would trigger the public policy exception.
Court of Appeal in the present case seems to have gone rather further than you suggest is necessary. If we look, for example, at 178, they speak there about there being no inherent insuperable difficulty in the court considering the evidence in relation to threats made and assessing whether they were lawful or not according to the standards set out in the treaties. So you would say it's not necessary to go that far.
It's not necessary, but that there's nothing to preclude them from going that far, but it's not strictly necessary on our approach.
Thank you.
This may have implications for how active state doctrine applies also.
Yes.
I mean, for example, you gave an example earlier of a threat to assassinate a finance minister. I mean, duress to the person would be a classic example of duress, and one would have thought it would vitiate a contract once, if it were established. End of story. And it would really be beside the point, one might think, whether in a wider sense it's been it constitutes an active state for the purposes of the law of tort, for example.
I mean, essentially what one sees the Russians trying to develop here is some kind of concept of foreign act of state in developing the English law of duress, which we say is inappropriate.
Can I raise a slightly different point, which is,
Foreign crown act of state.
I mean, we know it's these proceedings being brought on the instructions of Russia,
Yeah.
but it could, I mean, they're tradable notes, and in principle it could have been anyone else bringing the claim, but presumably your defence would be the same.
Our defence would be the same, although there may be issues around notice of any third-party holder of the bonds as to whether they're on notice of Russian duress or not.
Pretty public.
But it's pretty public. And also the prospectus refers to Russian pressure. The judge records the prospectus in his judgment. The prospectus itself refers to punitive trade measures imposed by Russia to prevent Ukraine entering into the EU Trade Association Agreement. So it would be pretty public, as your lordship says.
I mean, what you're saying is if someone else had been rash enough to take these notes, they would have been faced with the same defence.
Yes. I don't shy away from that, although on the facts it was never envisaged that any other party would hold these bonds.
Although, the effect of a duress would be to render the notes avoidable. So the interest of a bona fide third party could be protected.
Might be affected by his notice of Russian duress.
Thank you.
Yes. And the defences to a restitution claim, if any, might be different in that circumstance too.
It's rather sounding as though this issue of the interaction between the English law of contract and international law may perhaps be at the core of this and require rather more attention than the Court of Appeal
Possibly, Madam.
appreciated.
But ultimately, we do say the standard is not one of technical unlawfulness. And Ukraine, as the court saw yesterday, pleads unlawful and or illegitimate conduct, and that Russian threats were not made for bona fide reasons. What Mr. Howard did was to use illegitimacy in a slightly different way to the way in which the Court of Appeal looked at it. In his case, in the sense in which he used it, illegitimacy was reduced to the residue of duress that is not unlawful, that are not unlawful acts. It assumes that duress is to be classified in all cases into one of two buckets, either unlawful or only illegitimate actions. And the reason he does that is because Mr. Howard is trying to say that the court cannot use public international law as a yardstick for either of the two types of duress. It can't be used as the yardstick for unlawful act duress because there is no English law absent incorporation. It can't be used, he says, as a standard for illegitimacy because that is like incorporation. But that is wrong if you start from the premise that the test to be applied in all cases is illegitimacy, and you can see that from the Court of Appeal judgment. In a domestic context, it obviously makes sense for the standard of legitimacy to largely be based on domestic law. Individuals and companies are generally not subject to public international law. But having reference to public international law as a guide for duress applied to states makes sense, as the Court of Appeal adverted to. And as I said earlier, if we can only refer to domestic law standards, then using force or making mala fides threats are just as illegitimate against states as they are against private persons. And what the Court of Appeal did in this case, in using international law as a way of elucidating, understanding and applying common law standards to duress committed by a state, is a modest use of established public international law standards where there is a firm domestic foothold, particularly standards of customary international law, and Article 2.4 being a classic example of that. The fact that conduct may also happen to be a breach of international law does not somehow kick away the domestic foothold. And what the Evia Luck shows is that English law standards are applied, but the standards of English law to be applied include English public policy, which will have regard to international law as necessary. And a point I'll try and make briefly, but English public policy could potentially involve refusing to enforce contractual rights procured by duress, putatively governed by a foreign law, even where that law would regard the contract as valid, let alone, as in the present case, a contract governed by English law. And in that context, it might be useful just to look at the Royal Pascalis case at Authority Volume 3. It's tab 17, that authority, MS 1149. This is another case arising out of Iraq, and the facts are slightly convoluted, but can I just ask you to note this part of the head note in relation to various companies operating in Iraq at the time of the war, between letters E and F, in order to secure the demobilization of the fleet and the repatriation of their employees, the plaintiffs negotiated and signed a finalization agreement with the Iraqi authorities, pursuant to which the plaintiffs paid large sums into bank accounts in Switzerland and Austria and waived all further claims under the dredging contract. And the issue that arose is whether that dredging contract could be relied on in the proceedings. And if we go, please, to the judgment first of Lord Justice Stuart Smith at MS 1164. And at letter C, Lord Justice Stuart Smith says there was no dispute that the finalisation contract was obtained by duress, and duress of the most extreme kind. Not only was their entire fleet seized, but the Iraqis were threatening to use the European employees of the joint venture as part of the human shield policy, to say nothing of the fate of the 356 non-European employees. Mr. Akers did not seriously dispute that as a matter of English public policy, the English court would not give effect to the finalisation agreement and the waiver of claims at the behest of the Iraqis. And then he says at his lordship says at letter E, I think that any civilised tribunal would refuse to give effect to it. In my opinion, this affords a complete answer to the plaintiff's claim on the basis that they failed to prove that it suffered any effective loss to form the basis of their sue and labour charge. And then, if we go, please, to Lord Justice Phillips, to page 1202, just for your notes, you'll see just above letter H, his lordship deals with the Dimscal shipping, the Evia Luck case, just below letter G, and there's quite lengthy citations from it over the page. And if we go, please, then to page 1204, just below letter E, where Lord Justice Phillips, as he then was, says, Lord Gough recognises the potential applicability in the context of a case of duress of the primacy over foreign law, of the distinctive policy of English law. And then, if you glance through that paragraph, we can pick it up at letter G, where Lord Justice Phillips says, the duress in the Dimscal shipping case was not of such a type as to violate some moral principle, which if it is not, ought to be universally recognised, referring to the Kaufman and Gerson case. It would be strange if duress of that type were to be rendered acceptable to the English court by virtue of the effect of a choice of law clause induced by the same duress, or because the law of the country with which the contract induced by duress had the closest connection regarded the duress as acceptable. My conclusion is that there remains a class of duress so unconscionable that will cause the English court as a matter of public policy to override the proper law of the contract. And then at 1205, just above letter C, so the basic facts as to the duties are not in issue. However much the effect of Kaufman and Gerson may have been narrowed by the Dimscal shipping case, I don't consider that there's any chance that under English law, duress to persons that was imposed in this case would be considered a matter for the approach adopted in the latter case rather than the former. The threat to use a large number of personnel as human shields is about as cogent and unconscionable form of duress as one can imagine. So this case underlines why the Court of Appeal below was right to ascribe such importance to public policy and the public policy exception of English law to the facts of this case. And the duress alleged in the Royal Scholars case was undoubtedly being carried out by Iraq in the prosecution of war. So one can see an act of state in play. I was going to turn then, if I may, to the question of incorporation of international law. The trustee seeks to recharacterise the case as requiring or involving the incorporation, our case as requiring the incorporation of international law. That is not correct. We don't shy away from reference to international law, whether as a cross-check or as a guidance for English notions of public policy and duress, to show that Russia's conduct was illegitimate. But that does not require the incorporation of international law into English law. Otherwise, the approach of the House of Lords in the Butts case makes no sense, as the Court of Appeal cogently observed. And my learned friend took you to KU, paragraph 150, in the judgment of Lord Mance yesterday, MS 1087. I don't need to go back to it. It talks about English law being shaped by international law, but shaping does not require incorporation. I'll also refer you in this context to Professor Brownlee, and we cite the relevant passage in our written case at paragraph 42 about the relevance of international law in shaping English law, where it can do so consistently with English law. There's also, again, if I can give the court another reference, it's worth reading in this context Mr. Sales, as he then was, article, which is at Authorities, Volume 20, tab 208, MS 7900, which has lengthy sections on the importance of dualism and the proper use of international law, including limits on the courts considering issues of war and peace, etc. But it also deals at MS 7915 with the entirely legitimate use of PIL as developing common law and informing its application to new factual situations. And it's noteworthy in this context, if we can turn to the Q8 case next, that the incorporation argument that the trustee seeks to run now was run and failed in the Q8 Airways case. If we go to Authorities, Volume 2, please. The case report begins at page 589, and we can go, please, to the House of Lords at page 78, MS 785. Mr. Howard took you to the facts of this case yesterday. MS 785, paragraph 32 in the judgment, in the speech of Lord Nichols. Paragraph 22, he says the effect of these Security Council decisions as a matter of international law is clear. Iraq and Kuwait are both members of the United Nations. Article 2.4 of the United Nations Charter provides that in their international relations, all members shall refrain from the use of force against the territorial integrity of any state. This is also a principle of customary international law, binding on states independently of the provision of the Charter. See the International Court of Justice in Nicaragua, which I hope to come to. Paragraph 23, he refers to the Security Council resolutions, but one sees Lord Nichols accepts that Article 2.4 of the United Nations Convention is a principle of customary international law, quite apart from the treaty obligations contained by the Charter, as having the character of jus cogens. And then paragraph 24, On behalf of IAC, Mr. Donaldson submitted that public policy exceptions to the recognition of provisions of foreign law is limited to infringement of human rights. One reads on, the submission is that the English court will not adjudicate upon the legality, validity, or acceptability of such acts, either under domestic law or international law. For a court to do so would offend against the principle that courts will not adjudicate upon the transactions of foreign sovereign states. The principle is not discretionary, inherent in the very nature of the judicial process. See Butts. KAC's argument, this submission by IAC continued, invites the court to determine whether the invasion of Kuwait by Iraq, followed by the removal of the 10 aircraft from Kuwait to Iraq, and the transfer to IAC was unlawful under international law. The courts were wrong to accede to this invitation, so that's the argument. My lords, this submission seeks to press the non-justiciability principle too far. Undoubtedly, there may be cases of which the Butts case is an illustration, where the issues are such that the court has, in the words of Lord Wilberforce, no judicial or manageable standards by which to judge the issues. And then at 26, this is not to say an English court is disabled from ever taking cognizance of international law, from ever considering whether a violation of international law has occurred. In appropriate circumstances, it's legitimate for an English court to have regard to the content of international law in deciding whether to recognise a foreign law. Nor does the non-justiciable principle mean that the judiciary must shut their eyes to a breach of an established principle of international law committed by one state against another, when the breach is plain and indeed acknowledged. And I'll come back to whether the reference to plain and acknowledged is a requirement. In such a case, the adjudication problems confronting the English court in the Butts litigation don't arise. The standard being applied by the court is clear and manageable, and the outcome not in doubt. That's the present case. And then 28 refers to Lord Wilberforce in a different way, noting the conceptions of public policy should move with the times. Oppenheimer and Cattermole, Lord Cross said that the courts of this country should give effect to clearly established rules of international law. This is increasingly true today as nations become ever more independent. The need to recognise and adhere to standards of conduct set by international law becomes even more important. And then paragraph 29 already noted that Iraq's invasion of Kuwait and the seizure of its assets were a gross violation of established rules of international law of fundamental importance. Breach of international law of this seriousness is a matter of deep concern to the worldwide community. Such a fundamental breach of international law can properly cause the courts of this country to say that, like the confiscatory decree of the Nazi government of Germany in 1941, a law depriving those whose property had been plundered of the ownership of their property in favour of the aggressor's own citizens will not be enforced or recognised in proceedings in this country. Of course, Oppenheimer and Cattermole did not require a United Nations Security Council resolution to find breach of jus cogens. Enforcement or recognition of this law would be manifestly contrary to the public policy of English law. For good measure, enforcement or recognition would also be contrary. And so he says, for good measure, enforcement or recognition would also be contrary to the country's obligations under the UN Charter. So those are separate points. And further, it would sit uneasily with the almost universal condemnation of Iraq's behaviour and with the military action in which this country participated, etc. And then if we could go, please, to Lord Steyn at MS 807. Paragraph 114. That brings me to the next step in the reasoning of the Court of Appeal, viz. That because the annexation of Kuwait and Resolution 369 constituted a breach of international law, it would be contrary to English public policy to recognise 369. Conception of public policy is and should be narrower and more limited in private international law than in internal law. Local values ought not lightly to be elevated into public policy on the transnational level, but rightly, the Court of Appeal found support in Oppenheimer and Cattermole. In that case, the House of Lords considered a Nazi law which discriminated against Jews. The flavour of the decision appears from the following passage in judgment of Lord Cross Chelsea, which I won't read, the Court will be familiar with. And then at letter D, it says, it's true, of course, that the present case does not involve human rights. That's how counsel for IAC sought to confine the public policy exception stated in Oppenheimer. I would reject that argument. It's true that the Court of Appeal broke new ground. It was the first decision to hold that the acts of a foreign state within its territory may be refused recognition because they are contrary to public international law. On the other hand, the Court of Appeal built on the Oppenheimer case, which was permeated, as the Court of Appeal observed, by consideration of the public international law. In my view, the Court of Appeal was right to extend the public policy exception beyond human rights violation to flagrant breaches of public international law. It does not follow, however, that every breach of international law will trigger the public policy exception. The present case, however, is a paradigm of the public policy exception. And then if we go to the next sentence between letters F and G, this sentence, marching logic to its ultimate unreality, Counsel for IAC submitted that the UN Charter and Security Council resolutions are not incorporated into our law and must be disregarded. And then he quotes from the Court of Appeal, showing a commendable internationalism, and says below letter H, I would endorse this observation. I'd add a few observations. Not only has the Charter of the United Nations been adhered to by virtually all states, that is 189 states, but even the few remaining non-members have acquiesced in the principles of the Charter. Generally accepted that the principles of the United Nations Charter prohibiting the use of force have the character of jus cogens, i.e., as part of the peremptory public international law, permitting no derogation. And then he goes on to deal with the Security Council resolutions for added measure. At same page, paragraph 115, Mr. Jaffe draws my attention to the end of paragraph 115 says, the public policy condemning Iraq's flagrant breaches of public international law is yet another illustration of such a truly international public policy in action. This international dimension reinforces the view of the Court of Appeal. I'm grateful. And then finally, if one turns to Lord Hope, at page 814, paragraph 138.
Sorry, reference again.
I'm sorry, page 814 at the MS numbers, page, paragraph 138 in Lord Hope.
Thank you.
Where his lordship accepts that it's clear that narrow limits must be placed on any exception to the Act of State rule, but then at 139, the top of the next page, so it doesn't follow, as Mr. Donaldson for IAC has asserted, that the public policy exception can only be applied where there's a grave infringement of human rights. It refers to Lord Cross in the Oppenheimer case. And then letter B, as Mr. Justice Upjohn put it in the Helbert Wag case, the true limits of the principle are to be found in considerations of public policy as understood in the courts. And then he complains about the rigidity to the concept which Mr. Donaldson's submission sought to enforce. And at 140, says, as I see it, the essence of the public policy exception is that it is not so constrained. The golden rule is that care must be taken not to expand its application beyond the true limits of the principle. These limits demand that where there is any room for doubt, judicial restraint must be exercised. But restraint is what is needed, not abstention. There's no need for restraint on grounds of public policy where it's plain beyond doubt, beyond dispute, that a clearly established norm of international law has been violated. And I'll come back to the beyond dispute point. The facts which bear on this issue are quite straightforward, and you see reference to Security Council resolutions there. And then if we go to paragraph 144 at page 816, it's not disputed that our courts are entitled on grounds of public policy to decline to give effect to clearly established breaches of international law when considering rights to property which is located in England. And then at C, he says IAC could not rely on the Act of State doctrine if England was the country of the lex situs at the time when the breaches of international law were committed. But why should effect not also be given here to international law, where to do so can be justified on grounds of public policy? 145. In my search for an answer to this question, I would take as my guide the observations of Lord Wilberforce in Brathwaite. he said that conceptions of public policy should move with the times, and that widely accepted treaties and statutes may point in the direction in which such conceptions, as applied by the courts, ought to move. It would seem, therefore, to be contrary to the principle for our courts to give legal effect to legislative and other acts of foreign states, which are in violation of international law, as declared under the Charter of the United Nations. And he says at the end of that paragraph, the maintenance of the rule of law is an important social interest. And then if I can just give you some references to Mr. Justice Mance in first instance in the Kuwait case. It's Authorities, Authorities Bundle 11, tab 99, and the relevant page numbers which I'd ask the court to look at. Page 57, MS 4169, and page 62, MS 4174, where Mr. Justice Mance makes clear that there are no absolute no-go areas in terms of the areas in which English courts can have regards to international law in setting its own public policy. Now, on the face of it, Kuwait was a very promising case for the application of the Foreign Act of State doctrine. Iraq had annexed Kuwait and issued a decree taking ownership of Kuwait Airways aircraft. The strong echoes of the Soviet expropriation cases of early in the last century, like the Princess Paley-Olga case, where foreign expropriation decrees were recognised and given effect to by the English courts. The court in Kuwait Airways was asked to refuse, and did refuse, to recognise expropriation in that case, because it was a clear violation of international law. Kuwait, therefore, goes further in this case, because the court in Kuwait considered the validity of formal acts of the Iraqi government on what it considered to be its own annexed territory. But it showed that the English courts can and will adjudicate on claims and will draw on international law as necessary. Now, in Kuwait, the breach of international law was, of course, incontestable, as we've seen. But Kuwait cannot be distinguished on the basis that the facts were not in dispute. That point was run and lost by Her Majesty's government in Belhaj. If it were otherwise, simply by disputing the facts, a state could avoid any judicial determination of its wrongful conduct. There would, for example, be no public policy exception at all, providing the state was willing to issue a bare denial. And in this context, it's useful to look at Belhaj. Authorities Bundle 1. I pause there to say one can't imagine the result in Kuwait would have been different if Kuwait had been a member of the Security Council and had vetoed the Security Council resolutions. If Iraq had been a member of the Security Council and vetoed the resolutions, it's very doubtful that the House of Lords would come to a different conclusion. It recognised Article 2.4 as jus cogens. But if we go to Belhaj, Authorities, Volume 1, and if we could start, please, at MS 79 in the judgment of the Court of Appeal. Paragraph 114. Now, in this case, my Lord Lloyd Jones will recall that the Court of Appeal said that Foreign Act of State was engaged. And at paragraph 114, the Court of Appeal says, the central issue for determination is whether this court should go beyond the Oppenheimer case and the Kuwait Airways case and apply the public policy limitation in a case where the court, if it exercised jurisdiction, would be required to conduct a legal and factual investigation into the validity of the conduct of a foreign state. The ratio of the Kuwait Airways case does not confine the limitation to cases where such an investigation is unnecessary. And then while I've got this page open, I would commend to the court paragraph 115, which says that a fundamental change has occurred within public international law. Traditional view of public international law as a system of law merely regulating the conduct of states amongst themselves on the international plane has long been discarded. In its place has emerged a system which includes the regulation of human rights by international law, a system of which individuals are rightly considered to be subjects. A corresponding shift in international public policy has also taken place. See the observations of Lord Steyn in Kuwait. These changes have been reflected in a growing willingness on the part of courts in this jurisdiction to address and investigate the conduct of foreign states and issues of public international law when appropriate. And then if we go to Lord Neuberger in the Supreme Court at MS 176, and at 176, you see at paragraph 166, throughout that paragraph, 166, you see what Lord Neuberger is addressing are allegations. They're not findings, they're allegations of detention, rendition, etc. And at 167, he says, in my view, at least on the evidence available so far, in agreement with Lord Mance and Lord Sumption, the acts complained of by Mr. Belhaj and Ms. Budchar do not fall within the third rule. There is no suggestion that there's some sort of formal or high-level agreement or treaty between any of the states involved that govern the cooperation between the executives of the various countries concerned. So already mentioned, the mere fact that officials of more than one country cooperate to carry out an operation does not mean that the third rule can be invoked if that operation is said to give rise to a claim in domestic law, positively inimical to the rule of law if it were otherwise. And then this, at 168, having said that, even if the third rule otherwise applied, I would still hold that this was the case where, assuming that the claimants were detained, kidnapped and tortured as they allege, so we're talking still about allegations, the public policy exception would apply. In that connection, Lord Sumption's impressive analysis of the relevant international law is important in the present context because I consider that any treatment which amounts to a breach of jus cogens or peremptory norms would almost always fall within the public policy exception. And that's critical.
So does that mean, Mr. Banky, that it's enough to make the allegation of a breach of a fundamental rule?
In our submission, yes. And in Belhaj, we know we're dealing with that allegation. There'd be no finding of fact. Obviously, there has to be a proper basis for the allegation, in fact. So if it was a hopeless allegation which had no sustainable basis, then one could see why a court might not address it. But as long as it's an allegation which, on its face, requires investigation, then it needs to be investigated. One gets that clearly from Lord Sumption if we go to paragraph 267 at MS 220. So in paragraph 267, Lord Sumption says this: Secretary of State submits that unless the facts are undisputed or indisputable, as they were in Kuwait Airways, the Foreign Act of State doctrine precludes any examination of the facts. In my view, this submission fails to distinguish between two different inquiries. One, an inquiry into the lawfulness or validity of the alleged act of state, and two, an inquiry into the question whether there is any factual foundation for applying the Foreign Act of State doctrine at all. Whenever the Foreign Act of State doctrine is invoked, the court must decide whether it applies. If it cannot do it by reference to the pleadings or admissions, it must examine the evidence, This may involve examining what the state has done. And then if we go over the page, MS221, second line, page 221, same paragraph. The need to establish a factual foundation for the application of the doctrine must equally apply where the issue concerns not the character of the act, but the availability of an exception. And just for your Lordship's note, in the Court of Appeal in Belhage at 88 to 93, the Court of Appeal makes the same point, effectively, that the need for investigation or trial didn't preclude the application of the exception. And it was drawing on the passage from Lord Sumption that I've just cited, that at paragraph 308, subparagraph Roman 4 of his judgment, don't need to turn it up, Mr. Justice Blair held that Ukraine had established a sufficient factual foundation for consideration of the Foreign Act of State doctrine. In this case, because its case on duress was credible and had not been answered. And that conclusion by the judge at first instance is referred to by the Court of Appeal, paragraph 164 of its judgment below. And just while we've got Belhage open, if one goes back to paragraph 151 at MS 173, just ask the court to note paragraph 151 through to 157, while accepting that Foreign Act of State was essentially a concept of English domestic law, Lord Neuberger acknowledges that it's been influenced by developments in international law. So I'd ask the court to take note of those paragraphs 151 to 157. And similarly, paragraphs 252 to 253 of Lord Sumption. Again, one sees no hint of a need to incorporate public international law into English law to allow it to shape English law, particularly English public policy. Foreign Act of State is in fact a good example of the common law drawing inspiration from public international law without international law being thereby incorporated. It remains a concept, as Lord Neuberger says, of English domestic law. It's a good example of the common law developing by reference to international law standards, but none of this involves some process of incorporation, simply the common law using valuable sources to guide its development. Now, Mr. Howard grudgingly accepts that on the facts of the Kuwait Airways case, where there is a UN Security Council resolution and admission that the annexation is wrongful on the international plane, the court can and indeed should consider the case. So he would accept there was a domestic foothold in the Kuwait situation. But what is that domestic foothold? The trustee's argument must be that prior to any UN Security Council resolution being passed, there would have been no domestic foothold. Or similarly, for so long as Iraq denied the conduct, there would be no domestic foothold. But presumably after the admission by Iraq and the UN Security Council resolution, presumably there is then a domestic foothold. So his argument must proceed on the basis that the existence of a domestic foothold changes depending on the facts as they developed. But as we've seen, that is wrong and contrary to Belhage. If an inquiry into the facts is required to see if a public policy exception is engaged, then that inquiry has to take place, providing there's a sufficient factual foundation, as the judge held there was in this case. Now, it's apparent from Lord Neuberger's judgment in Belhage that the law in this area remains in a state of development and is to be approached on a case-by-case basis. That's paragraph 118 and 133 of Lord Newberger. I won't turn them up. But in that context, I would refer, without turning it up, to a decision of the Court of Appeal in a case called World Online, which is at Authorities, Volume 10, Tab 87, paragraphs 11 to 12, MS 3925, where the Court of Appeal held that the absence of decisive English authority where the law is not settled is a good reason not to grant summary judgment. And certainly no situation similar to the present case has yet arisen and been determined by the appellate court, and it underlines why this case is unsuitable in our submission for summary determination. We better resolved after relevant findings of fact by a trial judge. This approach is relevant too when we come back to look at Ukraine's appeals tomorrow. Now, here there are several primary sources of potentially relevant international law to guide the court in the application of the English law of duress to the facts of this case. And the Court of Appeal lists these at paragraph 166 of its judgment, which I won't turn on, but what I'd like to do is to turn to some of the key examples relied on. First, Article 2.4 of the UN Charter which the court will find at Authorities, Volume 19, Tab 180, MS 7454.
Could I have the number again?
I'm sorry, the MS number is 7454.
7454, thank you.
7454. And Article 2.4 is found at 7456. You see, Article 2.4 provides that all members shall refrain in their international relations from the threat, I emphasize threat, or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purpose of the United Nations. So one sees that threat is just as much objectionable under Article 2.4 as the actual use of force. And Article 2.4 as a whole reflects customary international law and is fundamental to the system of international law. The Court of Appeal, we go back to the Court of Appeal judgment, is in Court Volume 2, page 72, MS 8673 first. Paragraph 165 at MS 8673. The court says it's common ground that the use of force by one state against another and also the threat of use of force by one state against another are in violation of a general law of international law. The norm finds expression in Article 2.4 of the Charter of the United Nations, and then Lord Sales sets it out. And then if we go to paragraph 180, page 72, MS 8680, where Lord Sales says the public policy exception to the third rule is founded upon English public policy, is not restricted to cases of grave infringement of human rights, see Belhage. In our judgment, there is an especially strong public policy in this country that no country should be able to take advantage of its own violation of norms and jus cogens. This is adverted to by Lord Neuberger in Belhage at paragraph 168, which we looked at, albeit in the context of the particular claims in issue in that case. However, it is significant that Lord Neuberger did not confine his reasoning to particular norms relevant in that case, but stated the position more widely by reference to the category of jus cogens itself. In our view, this is because domestic public policy here is informed by public policy inherent in international law, when it identifies norms as peremptory norms with the character of jus cogens. Identification of norms as having that character indicates the strong international public policy which exists to ensure that they are respected and given effect. Domestic public policy recognises and gives similar effect to that strong public policy. There is no norm more fundamental to the system of international law and the principle of the rule of law than that set out in Article 2.4 of the UN Charter. So, I see, not on that clock, but on my own watch of the time.
Yes.
Maybe a convenient
Yes.
moment.
Yes, certainly. 2 o'clock.